Yeah, too much. Right. Hello, everybody. My name is Aleksandra Drożdż, and I'm an intellectual property lawyer. Law and art are my all-time favorite things to talk about, so I decided to combine them and tell you about limits of protection of the conceptual art. Basically, I'm here to throw 2 or 3 wet blankets on the belief that there is copyright protection of conceptual art. Defining art is both hard and subjective. Yes, sorry. Defining art is both hard and subjective. The legal disputes are particularly spirited when it comes to conceptual art, which has loosened the limits of aesthetics, form, function, and so on. But law must arrive at sane solutions to such difficult problems. Yes, thank you very much. Let's just start with a basic definition that art may be characterized as an expression. No, back. Let's go back. May I have the previous slide? Okay. That art is to convey emotion. It acts as a commentary. There is the long-standing general reluctance of courts to confront the issue. In a very well-known US Supreme Court decision, it was stated that it would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of worth of pictorial illustrations. At the one extreme, some works of genius would be sure to miss appreciation. Their novelty would make them repulsive, until the public had learned the new language in which the author spoke. Please have a look at the object Bird in Space. This is a sculpture by Konstantin Brancusi. It was imported into the United States for an exhibition, but the customs official decided this is just a piece of metal. This resulted in a 40% duty. It took a very lengthy trial before the customs court ultimately reached a conclusion that we can clearly see today. This is a beautiful work of art which evokes a bird with only its essential form. But apart from the discussions on the legal definition of art, there are other major issues at hand. There are 2 leading reasons for the limitation of copyright protection for conceptual art. Firstly, there is the fixation requirement. The work must be sufficiently fixed, and it must be stable and permanent to be perceived not just within the transitory period. And the second one is the idea versus expression dichotomy. Copyright does not protect concepts. It only protects a particular form of expression of a concept. This is a work of a painter, Chapman Kelly, in Grant Park in Chicago. It was publicized as living art. Well, the city decided to make some pedestrian footpaths in it, and the artist sued for the infringement of the right of integrity. The court decided that the work is not fixed. The seeds and the plants of the garden are naturally in a state of perpetual change. The essence of the garden is its vitality, not its fixedness. And because of that, living art is out of scope of copyright protection. Such problems may arise in other cases when a medium is constantly changing. But on the other hand, there is some interesting case law which treats the fixation requirement differently. In Williams versus Arctic, the court has stated that the fixation requirement is met when work contains some kind of change, as long as it is substantially repetitive, for it to be deemed permanent. And it reminded me of a French saying, plus ça change, plus c'est la même chose, which basically means the more things change, the more they say the same. And in this case, the images of the game were, no, yes, let's stay here, were changing. They were repeating over and over again, regardless of the fact how the player operated the controls. And the court decided that substantial part of it it's similar, and it may be deemed permanent, and it does not threaten the fixation requirement under Copyright Act. One may think that the garden is also quite repetitive. So just keep in mind the fixation requirement, but note that it may be interpreted differently. Apart from it, there's, as I already told you, about the idea versus expression dichotomy. Copyright does not protect concepts, it only protects a particular form of expression of a concept. And thank you. No. I'm not very technical. Yes, let me show you some examples. The first one is Piano Burning by Anna Lockwood. In the 60s, a lot of things were set on fire, Jimi Hendrix's guitar included. So Anna Lockwood did a performance where she set a piano on fire, which made quite a terrible sound. You cannot infringe this piece. This is just an idea. Another one is The Sound of Ice Melting by Paul Koss. This is also a sound piece. It includes blocks of ice and the microphones amplifying the sound. And it focuses the perception on the things that would seem stable, but actually they are changing all the time. The ice is popping and cracking, and it puts the spotlight on impermanence. I think it's very beautiful, but this is also just an idea. Well, let's continue. Of course, you may photograph or record those ideas. Such photographs or videos would be copyrightable, but they would constitute, as Robert Clarida, an intellectual property lawyer, said, the Magritte effect. Let me explain this thought. So there's a painting, very well-known one, by René Magritte called The Treachery of Images. It shows an image of a pipe, and in French it's written that this is not a pipe. So conceptual works are not really reducible to their representation in a photograph or a video. The work is not a copy, and the work is not a representation of the work. So this is why I would like to advise you not to have high hopes for copyright protection for conceptual art. Thank you.